Hello students, welcome to the lecture on proposal and acceptance, and after this lecture we will be able to learn the following objectives. Explain concept of offer and acceptance formula, discuss the contract, describe the formation of contract, define the capacity to contract minor. Offer and acceptance, collectively called mutual assent, is the most basic building block by which every contract is formed. Without a valid offer and acceptance, no contract will be made. An offer is said to be made when there are words or actions by the offer or that create a reasonable expectation in the offeree that the offerer is willing to enter into a binding agreement based on the articulated terms. Let us now discuss the concept of offer and acceptance formula. Offer and acceptance is a formula developed during the 19th century, usually used to identify the moments before a contract when all parties come to terms of agreement. Terms of offer and acceptance are included in a contract, with the offer being the indication of what a person is willing to put forward. Offer and acceptance agreements are essential anytime a contract is being drawn. It is the one thing that binds parties together as well as defining the condition of service. There are a variety of contracts that exist, and each legal contract contains terms of offers and acceptance. Breach of contract. It is a legal term that describes a violation of a contract or agreement in which one party fails to fulfill its promises or by interfering with the ability of another party to fulfill its duties. In order for a breach of contract to be upheld by a court, it must meet all of these requirements. The contract must be valid, that is, it must contain all the essential contract elements so that it can be heard by a court. The plaintiff must show that the defendant breached the contract. The plaintiff did everything required in the contract. The plaintiff must have notified the defendant of the breach. Defenses to breach of contract. A defendant may offer a reason defense why the alleged breach is not really a breach of contract. Common defenses against a breach of contract are fraud, which knowing misrepresentation of the truth or concealment of a material fact to induce another to act to his or her detriment. Duress, which occurs when one person compels another to sign a contract through physical force or other threats. Undue influence is similar to duress. Remedies for breach of contract. If one party is found to be in breach of a contract, the plaintiff has several ways to be made whole. Call a remedy. The most common remedy is monetary payment. Types of breach contract. Material breach. It is a breach that is significant enough to excuse the aggrieved party from fulfilling its parts of the contract. Partial breach. It is not as significant and it does not excuse the aggrieved party from its duties. Anticipatory breach. A party may breach a contract by doing or failing to do something that shows intention not to complete duties under a contract.
Hey, do you have a minute?
Sure, but I'm about to have lunch, so can you make it snappy?
Of course. I'm working on that case you gave me.
The one where the stripper forged her mother's will?
No. The trust case.
Oh, the one where the old woman wants to leave all of her money to her 24 cats?
No, the constructive trust case where our client stole the
hubcaps. Excuse me. Hey, Natalia, can you please bring me that sandwich that's in the fridge? So how is the hubcap case going?
No, it wasn't hubcaps. Our client, she stole.
Allegedly stole. She allegedly stole her uncle's stamp collection, like 10 years ago. Oh yes, and the uncle is asking the court to impose a constructive trust?
Yes, that is the one.
Isn't the joint pre-trial conference memorandum due on that case this week?
Yes.
So, goodness, where is Natalia with my sandwich? So this case, it's one where they're suing our client and asking the court for the equitable remedy?
Yes. It's very.
Is it complicated?
Well, yes, but I think I may have found a way to win.
That's your job. What was the cause of action specifically?
Well, they claim both unjust enrichment and breach of fiduciary duty, because, like you said, Our client allegedly stole the collection from her uncle almost 10 years ago, way back in the year 2002. It's a stale claim.
Stale as yesterday's donut. Okay, so since the uncle filed equitable causes of action of breach of fiduciary duty and unjust enrichment, wouldn't the doctrine of laches apply to bar his claim as untimely?
Yes, but there is an actual statute of limitation on constructive trusts.
Get out. Really? Well, good. Because the laches doctrine can be so, it just gives so much discretion to the judge. So what is the statute of limitations on that?
The court has applied the catch-all statute of limitation of 4 years after the cause of action accrues.
Is there a discovery rule like there is in fraud cases where the statute doesn't start running until the fraud is discovered?
Well, kind of. The courts have held that the statute of limitations starts to run at the time of the wrongful taking, assuming there is actual notice. So it's like the discovery rule.
Okay, then that is not going to help our case.
Yeah, because the uncle didn't really find out that the collection was missing, allegedly missing, until about a year ago.
Well, so, that's not good. Where the hell is my lunch? So we were stuck with that?
Well, maybe not. I found this doctrine in a treatise on equity. It's called the concurrent remedy rule. It's based on the equitable maxim that equity follows the law.
What's that about? And where's my damn sandwich? Natalia.
Well, the plaintiff in this case is seeking money damages, not the return of the stamp collection. And damages is a legal remedy, not an equitable one. So courts look beyond the words used in the pleadings and look to the actual remedy the plaintiff is seeking. So regardless of the uncle's attempt to use the magic words of equity, if there are any analogous adequate legal remedies, the uncle must first avail himself of those. And the courts apply the statute of limitations applicable to that cause of action, not the equitable ones. And the analogous legal remedy would be...
Wouldn't it be conversion?
Yes. It is conversion that's the cause of action at law.
Okay, so what's the statute of limitations on conversion actions?
It's 2 years from the time of the wrongful taking.
Is there a discovery rule? Where are you going with this, and where is my sandwich?
No, there is no discovery rule on conversion actions per se. The only rule is that if the wrongdoer fraudulently concealed the wrongful taking, concealed the fact that he stole something, then the statute of limitations runs from the date of the discovery of the theft. And our client, though she may have stolen it, she didn't conceal the theft.
Then what you were saying is that if the court applies the concurrent remedy rule to our case, it will consider the remedy to be the legal one, of conversion, and apply the 2-year limitations period without regard to when the uncle discovered the theft. Yes. And since there's been no allegation or evidence that she covered up the theft, then the statute of limitations ran out on the uncle's claim 2 years after she stole the stamps, way back in the year 2004, regardless of when the uncle found out about our client stealing it. And that means their case will be dismissed. Have I got that right?
Yes.
Okay, well, nice work. And good luck at the hearing on Friday. I hope the judge buys your concurrent remedy rule argument. And if he does, I'll buy you dinner.
I should probably buy dinner for you. I ate your sandwich. I ate your lunch. I saw that sandwich and I ate it, and...
You're fired. And I'm going to have to sue you for conversion, Miss C.
But oh dear, well, it was not good. It was not good. It's stale. As the uncle's claim. Oh no. I think I'm going to be sick. Uh-oh.
Really? Oh, not on the carpet, please, or I'll have to sue you for damages too. Which, as I recall, is a legal remedy, is it not?
Uh-oh. Oh dear.
Well, you may have a future at this firm as my food taster.
Let us now discuss contract. A contract is an agreement between 2 or more parties to do, not do, or to promise something. Contracts can come in many forms: oral or written, implied or express, and legally enforceable or not.
Good morning, Year 11. Congratulations, you have made it to Term 4. Get excited.
Yeah. Woohoo. Totally not even being sarcastic.
Yes. Well. Cough cough. Moving on. This term we will be taking a look at contract law. Now, as you may or may not know, each of us makes agreements on a daily basis. It might be something as simple as going to the school cafeteria to purchase a bottle of Coke on your lunch break, or as complex as signing a contract of employment.
Sounds complicated. I think I should quit while I'm ahead.
Giving up before you even get started will never get you anywhere. Put simply, an agreement involves an exchange of promises between two or more people. One person promises to do something and in return another person promises to do something.
Now I understand. Who would have thought it could be so simple?
Not quite. An agreement is commonly known as a contract where the law enforces the promises made if the promise is breached. Before parties can reach an agreement, there must be an offer or an acceptance of that offer. An offer is a communication amounting to a promise to do something if the person to whom the offer is directed does something in return.
But how am I meant to know when an offer is really an offer?
It's a good question. Glad you asked. An offer must be distinguished from an invitation to treat, and this is not always a simple process. The question to ask is, did the party making the statement intend that an affirmative response would give rise to an agreement or simply result in further negotiation? So what is an example of an invitation to treat?
I know. I know the answer. Are items in a grocery shop an invitation to treat because customers made an offer when they select an item for purchase?
Spot on. That is correct. Another example is a vending machine. A vending machine is an invitation to treat. You make an offer when you put money in and select what you wish to purchase. It accepts your money and dispenses your purchase. Ding, ding, ding. A contract was established.
Wow. Who would have thought contract law could be so interesting? I can't wait to learn more.
Yes, very exciting stuff.
Everyday agreements. People tend to think of written documents when the topic of contracts comes up, but the most common types of contracts are actually oral contracts. People pretty much enter into at least one oral contract every day. Implied or express. Contracts and their terms can be implied, which means that the terms are understood without being specified, or expressed, which means that all of the details are included. Other elements of contracts. Offer and acceptances are fundamental parts of contracts. Without them, parties might be bound to contracts without their consent. Enforceability. Contracts might or might not be enforceable by law. Whether specific contracts are enforceable by law depends on numerous factors, including whether the parties intended their contracts to be legally binding or legally enforceable. Elements of a contract. A contract is an agreement reached after sufficient consideration to do or refrain from doing some legal action. A contract is considered valid when two or more parties with capacity make an agreement involving valid consideration to do or to refrain from doing some lawful act. If these elements exist, the contract is valid. If one or more of these necessary elements is missing, the contract is void or voidable. The following are 6 elements that are to be held to determine whether or not the basic components are present and meet legal criteria for a valid contract. Number 1, all parties must have capacity to enter the contract. Number 2, an offer must be made. Number 3, consideration must be exchanged. Number 4, the parties must be in mutual agreement. Number 5, the contract's object and purpose must be legal. And number 6, the form of the contract must meet the legal requirements. Let us know the formation of contract. All contracts are made by the process of a lawful offer by one party and the lawful acceptance of the offer by the other party. Proposal. An offer involves the making of a proposal. The term proposal is defined in the Contract Act as follows. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. Section 2A. Offer. A proposal is also called an offer. The promiser or the person making the offer is called the offerer. The person to whom the offer is made is called the offeree. Promise and acceptance. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. Section 2B. The person making the proposal is called the promiser and the person accepting the proposal is called the promise. Section 2C. Effect of offer and acceptance. Offer alone and acceptance alone are inactive, inert or powerless. When separate, they cannot lead to the formation of a contract. But an offer together with acceptance leads to a contract which is enforceable by the court provided the other essential elements of contract exist. Offer. Rules regarding offer. The Contract Act contains various rules regarding offer or proposal. They can be summed up as follows. An offer may be expressed or may be implied from the circumstances. An offer may be made in two ways. Number A, by words spoken or written, and number B, by contact. An offer may be made to a definite person, to some definite class of person, or to the world at large. An offer made to a definite person or a definite class of person is called a specific offer. An offer sent to all person or the world at large is called a general offer. Legal relationship is required. The offer must be one which is capable of creating a legal relationship. A social party or an invitation to play cards is not a legal relationship. A mere statement of intention is not an offer. A distinction is usually made between an offer and a statement of intention. Price lists and catalogs and enquiries for customers are merely statements of intention. They are not regarded as offers but as invitation to others to make offers. Offer must be communicated to the offeree. A person cannot accept an offer unless he knows of the existence of the offer. An offer may be conditional. An offer may be made subject to condition. In such cases, the condition must be clearly communicated to the offeree. If a person accepts an offer without knowledge of the condition, the offerer cannot claim fulfillment of the condition. But if the conditions are clearly written or expressed and should have been known to the offerer, he cannot plead ignorance of the condition. Printed contracts. Printed contracts are standard forms of contracts, often contain a large number of terms and conditions which exclude liability under the contract. Acceptance. An offer can be accepted only by the person or persons for whom the offer is intended. An offer made to a particular person can only be accepted by him because he is the only person intended to accept. An offer made to a class of person can be accepted by any member of that class. An offer made to the world at large can be accepted by any person whatsoever. Rules regarding acceptance. The acceptance of an offer to be legally effective must satisfy the following requirements. Must be an absolute and unqualified acceptance of all the terms of the offer, Section 7, Clause 1. Conditional acceptance. In accordance with English law as well as with the terms of the Contract Act, an acceptance with a variation is no acceptance. It is simply a counter proposal which must be accepted by the original promisor before a contract is made. But an acceptance is not called conditional if an immaterial term is added or if there occurs any misunderstanding between the parties for the interpretation of collateral terms. Contract subject to condition. There are cases where an immediate binding contract is formed, although some of the parties' rights and obligation may be dependent upon the happening of a particular event. Clarification. The seeking clarification of offer neither amounts to the acceptance of the offer nor to the making of a contrary offer. The acceptance must be expressed in same usual or reasonable manner, Section 7, Clause 2. The offeree may express his acceptance by word or mouth, telephone, telegram, or by post. An offer may also be accepted by conduct. If the offeree does what the offerer wants him to do, there is acceptance of the offer by conduct. Mental acceptance or uncommunicated assent does not result in a contract. No contract is formed if the offeree remains silent and does nothing to show that he has accepted the offer. Acceptance cannot be implied from silence of the offeree. The mode of acceptance. Where the promiser prescribes a particular mode of acceptance, the offeree must follow the particular mode of acceptance. If the offeree fails to follow the prescribed mode of acceptance, the proposer may, within a reasonable time after the acceptance is communicated to him, insist that the proposal be accepted in the prescribed manner and not otherwise. But if the proposal does not insist upon it, he accepts the acceptance as actually communicated. Section 7, Clause 2. Time of acceptance. If the offerer prescribes a time, the acceptance must be done within that time. If no time is prescribed, the acceptance must be done within reasonable time. What is reasonable depends on the facts of the case. When acceptance is complete, Section 4 of the Contract Act lays down that the communication of an acceptance is complete as against the proposal when it is put in a course of transmission to hint so as to be out of the power of the acceptor, and as against the acceptor when it comes to the knowledge of the proposal. Before offer. Acceptance must be given before the offer. This is the natural sequence. There cannot be acceptance before the offer is given from any person. Communication of offer and acceptance. Section 3 of the Contract Act states as follows. The communication of proposal, the acceptance of proposal, and the revocation of proposals and acceptances respectively are deemed to be made by any act or omission of the party promising, accepting, or revoking by which he intends to communicate such proposal, acceptance, or revocation, or which has the effect of communicating it. How is an offer to be communicated? An offer may be communicated to the offeree or offerees by word of mouth, by writing, or by conduct. A written offer may be contained in a letter or a telegram. Section 4 states, the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. How is an acceptance to be communicated? Offer and acceptance by post. An offer may be made by post. An offer may also be accepted by post if there is no other mode of acceptance specially prescribed by the proposer. When a proposal is made through the post office is by implication the agent of the proposer. Therefore, a letter of acceptance duly addressed and posted is sufficient acceptance even though the letter does not actually reach the proposal. Offer and acceptance through telephone. Offer and acceptance can be communicated through the telephone, but there are certain rules regarding oral communication. If these conditions are satisfied and the other essential elements of contract exist. In an English court, it was held that a communication sent through a telex or a teleprompter machine in the office is valid. Microphone. There was an auction sale of plots of land. The terms including certain restrictive conditions were announced by a microphone. Option. An option is a conditional contract to do something. Standing contract and open proposal. Contracts for the supply of goods over a period of time are sometimes so worded that the buyer has an option as regards the quantity to be purchased and the time of purchase. Such contracts are called standing contracts. Revocation. Revocation of an offer. When does an offer lapse? An offer comes to an end and is no longer open to acceptance under the following circumstances. Section 6. By notice if the offerer gives notice of revocation to the other party. Once an offer is accepted, there is a binding contract by lapse of time after expiry of reasonable time. By failure of a condition precedent, an offer lapses by the failure of the acceptor to fulfill a condition precedent to acceptance where such a condition has been prescribed, by death or insanity, counter offer, by refusal. Revocation of acceptance. Section 5 of the Contract Act provides that an acceptance can be revoked any time before the acceptance comes to the knowledge of the proposer but not afterwards. Communication or revocation. According to Section 3 of the Act, the revocation of a proposal or an acceptance is deemed to be made by any act or omission of the party by which they intends to communicate such revocation or which has the effect of communicating it. According to Section 4 of the Act, the communication of revocation is complete. Minor. A minor is a person who is the age of 18. Anyone who has not attained the age of 18 is a minor. As a general rule, a minor's agreement is absolutely void, but there are certain exceptions to it, such as minor can be admitted to the benefit of transfers such as sale mortgage contracts. Minor can be admitted to the benefits of a partnership firm. It is allowed in law for a minor to elect to repay the debts that have been incurred during his minority after attaining majority. A control for the benefit of the minor entered into by the guardian can be specifically enforced. When a joint document is executed by minor and an adult, only the adult is liable in the contract. The document is void in respect of the minor and valid in respect of the major. Laws on legal contracts and mental impairment. When a person lacks the mental capacity to contract, any contract that person plays party to would be voidable with impunity. Mental impairment. Contracts entered into by the mentally impaired are generally voidable. Voidable contracts. If a person suffers from any kind of mental impairment and enters into a contract or transaction, the party can avoid the contract or transaction if his mental impairment prevented him from understanding the nature and consequences of the transaction. Incompetence. Under common law, a person is insane when he does not understand the nature and consequences of his own conduct. Now, in the end, let us summarize what we have learned in this lecture. Offer and acceptance, collectively called mutual assent, is the most basic building block by which every contract is formed. As long as the offer remains open, the party to whom the offers was communicated may accept the offer and effect a valid contract. The Supreme Court held microphones have not yet acquired notoriety as carriers of binding representation. Offer and acceptance is a formula developed during the 19th century, usually used to identify the moments before a contract when all parties come to terms of agreement. Breach contract is a legal term that describes a violation of a contract or agreement in which one party fails to fulfill its promises or by interfering with the ability of another party to fulfill its duties.